Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge Villarreal in Texas. And this divorce case has a lot of different issues going on. A lot of spite, but some interesting issues also. So I'll let you guys watch.
Jorge Martinez versus Denise Marie Salinas, cause number 2025 FLA 1199C3. Court marks Ms. Soto, present in person. Mr. Guadalupe Castillo, also present in person. Good afternoon to both.
Good afternoon, Your Honor.
Jorge Martinez, Denise Salas, are you present? Please step forward. As you make your way to the front, step in front of a microphone, pull a microphone as close to your mouth as possible, and tell the court, are you Denise Salinas?
Yes.
Welcome to court, Ms. Salinas. The court marks you present in person. The person to your right is your lawyer. Speaking to the microphone, Mr. Martinez, and tell the court, are you Jorge Martinez?
Yes, Your Honor.
Welcome to court. You're joining us in person. Your lawyer is on your left. Counsel, what is the announcement?
Judge, so the last time we were here, you asked me to draft and file a motion to consolidate and transfer the child support case into this matter. And I believe we're also pending the arrearage amount from the Attorney General's office because I believe they had that pending as well. I did file that motion. I did call County Court at Law number 1, but that order has not been signed yet. And it was filed as agreed, so I did request that it be signed without a hearing.
Because we missed a step. I didn't catch it. So there needs to be a request to transfer in an order, to transfer an order accepting, and then a consolidation. I didn't catch that. Yikes, that's why County 1 hasn't moved. All right. Is anybody here on behalf of the Attorney General's office?
Yes, Your Honor. Elias Alcantar on the Zoom with the Office of the Attorney General.
Mr. Alcantar, welcome to court.
I'm sorry, Your Honor, I didn't have this case on my docket.
This is, if you want to write this down, 2025 FLA 001199C3. Knowing that it's not been transferred in, accepted, or consolidated, where do we stand, Ms. Soto, Mr. Castillo?
Been diligent in trying to reach agreements on this matter. I don't know if Mr. Castillo would agree to just go forward once the case is transferred properly before the court on those contested issues, or are we trying every issue to the court? I think that if we limit it to what we have not agreed to, it shouldn't take very long because I believe it's only division of the sales proceeds and the child support amount that's in dispute right now.
Mr. Castillo?
That's basically correct, Judge, and the geographical restrictions, whether it's county, state, or unrestricted. But the only concern I have is whether the Attorney General is not in this case, and they don't have the files from Mr. Martinez from the other case where they have an agreement and
well, so just as a principle, as a matter of law, the court that has divorce jurisdiction subsumes the pending matter. So this court does have the legal authority to make some decisions with regard to the children. The question is, since there is a necessary party, i.e. the Attorney General's office, what position does the AG's office has, Mr. Alcantar?
Yes, Your Honor, as I stated, I didn't have this case on my docket today. Today, if the parties are ready to enter an agreement, I just like to hear it. I don't believe there's going to be an objection. If the parties are requesting more time, that's fine. We can review for intervention into this case.
Well, let me ask you both this. With regard to the, setting aside the property law division, because that's not in County 1, with regard to the children and child support, is there any dispute as to what the true and correct amount would be or who would have to pay it?
There is, Your Honor, because during temporary orders, my client, there was testimony that was trying to show that he was intentionally underemployed. So that's the issue here. The child support was set as originally set in County Court 1, which listed his available assets when he was employed with Webb County Sheriffs. He's now at a different position, and the argument was made and the court granted it that he was intentionally underemployed.
That's what the court in County 1 found.
No, you.
That's what
Your
I
Honor.
found. Okay, Mr. Castillo.
That's correct, Judge. On October 9, 2025, we had a hearing in this case. The transcript of the proceeding has been filed. And you did find intentional underemployment at that time. So we're still with the same set of facts. I don't think anything will change. So he's still underemployed, in our opinion.
And this is a matter you wish to contest at the final hearing.
Correct.
Well, it sounds like Mr. Alcantar, I mean, there isn't an objection from either side to proceeding today, and it sounds like your position only changes after the court makes a finding as to whether Mr. Martinez is gainfully and lawfully employed or whether he's underemployed. That would change the AG's position, would it not?
Yes, Your Honor. Well, mostly it's that we have not filed an intervention in this case. We already did have a final order in the prior cause, and they're bringing it into the divorce as to whether or not we're going in the divorce, as to whether or not I'm going to be filing the intervention into the divorce. That's something I still need to review, but if the court is going to be okay going forward today, I'd have no objection. If they're claiming intentional underemployment, that's some, I'm not sure if the court's going to hear that again, but that's something that I'm not aware of, that I'm not ready yet to go forward on.
Well, look, for purposes of today's hearing, counsel, there isn't a written motion for continuance. The court has heard zero objections from any side to continue. So that being the case, be prepared to go forward between now. So I've already listed it as the first contested matter this afternoon. So between now and then, talk to each other to see if you can't agree as to the employment, at least try to agree. If the court finds underemployment, this is what the numbers would be. If the court finds that he is gainfully employed, this is what the numbers would be. At least you have several scenarios to at least communicate about. And then I'll hear evidence and testimony and see what comes of that.
Yes. Thank you, Your Honor.
All right, stand by. Ms. Soto, Mr. Castillo, do you have an announcement?
Judge, we do have some agreements that the parties reached. The only issues that would be up for the court to consider would be the amount of child support, the arrearage repayment amount, and not the amount that's owed. Judge, we can go with the Attorney General numbers. We're just discussing how he's going to pay an additional amount towards that arrearage.
For the record, this is on cause number 2025 FLA 1199C3.
And the last issue, Judge, my client wanted a change in the possession dates for June and July. That is also up for discussion or consideration by the court.
So are you at an impasse point and you need some decisions, or do you need some more time to see if you can get there, Ms. Soto and Mr. Castillo?
Pastors, we did make some concessions, so did Ms. Salinas, but we're at an impasse.
Mr. Castillo?
That's correct, Judge. But I think maybe we can read the parts that we already are in agreement.
Sure.
Into the record, so we know exactly.
All right, go ahead.
In my the agreement that we have is wife and husband will be named joint managing conservators of the two children, with my client, the wife, having the primary right to designate the children's primary residence with geographic restrictions to Texas. And then, notwithstanding a mutual agreement in visitation, husband will be awarded the standard possession schedule. That's number one in conservatorship. The child support and the child support arrearage, we have an issue on that, Judge, that we need some guidance from the court, ruling from the court on that. As far as the division and debts, wife to be awarded the following marital assets: the wife's personal belonging and furniture in her possession, the wife's bank account, 100% of her retirement account, if she has any, and the vehicle in her possession. And from the sales proceeds deposited in the registry of the court, she will get 100% of those proceeds, Judge, which total around roughly 28,000. Husband will be awarded his personal belongings and furniture in his possession, husband's bank accounts, 100% of all his retirement accounts remaining after the withdrawal of the funds on or about July 15, 2025, prior to the filing of this divorce case. The vehicle in his possession, and he will not receive any sales proceeds from what is deposited in the court registry. As far as debts, wife shall be awarded the following debts: any credit cards and debts in wife's full name, wife's cell phone, any debts incurred solely by wife since the date of separation. Husband shall be awarded the following debts: any credit cards and debts in husband's sole name, husband's cell phone bill, any debt incurred solely by husband since date of separation. As far as federal income taxes, the parties shall file separate tax returns for 2025, and each shall be responsible for their respective wages, earnings, losses. Wife shall claim the children as dependent in 2025 and all subsequent calendar years. Husband agrees to remove criminal charges.
No, that's not an agreement, Judge. That's not an agreement. I don't think the court has jurisdiction to address that issue.
Oh, okay, well, then we'll address it when I cross-examine him. Okay.
And then there was one other judge that we had agreed that the parties stipulated to the jurisdictional requirements of the court, and that the record was going to be made that the divorce was being granted on insupportability with no expectation of reconciliation. And also, Judge, on the child support issue, that remains in dispute, but we did also agree that my client was going to keep covering the children in health insurance, medical, dental, and vision. He's covering that cost. And we also agreed that the Spectrum account that is under his name, but being used by Ms. Salinas, he's going to make all efforts, sign any documents necessary to transfer that account to her name only. And she's going to be assuming whatever balance may be on that account.
Is Ms. Soto, is that the extent of the agreement?
Yes.
Mr. Castillo, is that the extent of the agreement?
Except for bringing up the removal of criminal charges. I thought we had that. He's now saying no.
The charges are there, is there an information or indictment against any person that's a party of this case?
There isn't any, there was a complaint filed, but to my knowledge, there's no criminal case that's been indicted or no information.
So the question isn't as to charges, the question is as to a complaint. Ostensibly, you all are contemplating, discussing, and negotiating the effectuation of a complaint withdrawal, not the charges. Are those the communications?
That's correct.
So does this question lie not on the charges, but on the complaint?
The complaint, Judge. He filed the complaint during the divorce proceeding with the Laredo Police Department.
Closer to the mic, please.
The husband, Judge, filed a complaint against my client, the wife, with the Laredo Police Department, which I guess ends up with the district attorney at some time.
Knowing that there's a complaint and there aren't formal charges, Ms. Soto, does the answer to that question lie as to the withdrawal of the complaint and not as to charges?
Correct. They're requesting a complaint withdrawal, but my client's not willing to do that as well.
Understood.
And in that regard, Judge, then my client will not withdraw her charge of adultery as a reason for a ground for divorce. So we still have the adultery. And that's why, Judge, I have a subpoenaed witness, Janet Terrazas, she's in the courtroom. I would ask, invoke the rule at this time.
All right, well, this is going to be the first contested matter, I guess. Let me have Mr. Jorge Martinez, Denise Salinas step forward, and Ms. Soto, do you have any witnesses?
This is my client, Your Honor.
And Mr. Castillo, do you have any other witnesses besides Ms. Salinas?
Yes, Judge, I subpoenaed Janice Terrazas.
Ms. Terrazas, please step forward if you're present in front of the lower bench. Are you Denise Salinas? Welcome to court. Are you Jorge Martinez?
Yes, sir.
And are you Janet Terrazas?
Yes, Your Honor.
Welcome to court, Mr. Martinez, Ms. Salinas, Ms. Terrazas. I'm going to ask that you all raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, sir.
You may all lower your hands. Mr. Martinez, Ms. Salinas, you can now rejoin your lawyers at council table. You are parties to this case. Ms. Terrazas, you are a witness to this case and the rule has been invoked. What that means is that you now need to wait outside patiently until our court security officer comes and calls you in. Between now and then, you're not to talk to anybody about this case. If somebody tried to talk to you while this case is going forward, you're to notify court security. Do you understand this?
Yes, sir.
Oh, you can't listen to this case and you can't be in the hearing presence of anyone discussing this case and you can't go online and listen to it either. Do you understand all this?
Yes, Your Honor.
All right, you're excused.
Thank you.
Page 2, case 5, Jorge Martinez versus Denise Marie Salinas, cause number 2025 FLA 1199C3. When last we left off, the parties and a witness were sworn in. The rule was invoked. Ms. Soto, are you ready to present your case in chief?
Yes, I am, Your Honor.
Who is your first witness?
Ms. Denise Salinas?
This is respondent, Ms. Salinas. You are under oath. Ms. Flores, begin the witness stand microphone and audio. Ms. Salinas, the lawyers will be asking you some questions. I need you to answer after you hear the full question. If you hear or see one of the lawyers make an objection, pause, and I'll let you know if you can answer. Do you have any questions?
No, just that I'm hard of hearing, so I have to look at who's talking to me.
All right, so right now, Ms. Soto will be asking you questions.
Okay.
And Mr. Castillo will ask you questions after her.
Okay.
Anything else before we begin?
Yes, Judge, may I inquire, is there any other witnesses that Ms. Soto intends to bring up?
Any other witnesses besides the parties and Mr. Terrazas?
No, Your Honor, I'm not planning on calling any other witnesses.
Whenever you're ready, Ms. Soto.
Thank you, Your Honor. Ms. Denise Salinas, what is your current address?
Avenue.
Okay.
Apartment C35, Laredo, Texas, 78046.
And is that an apartment that was given to you by housing?
No,
Are you receiving any type of food stamps?
$200 of food stamps.
Are you receiving any other type of assistance?
I believe I only have Medicaid for this month.
Is that for you or yourself?
No, just for my children.
And how much do you earn at your job?
Hourly, monthly.
What's your hourly rate?
My hourly rate is $12.50. No. $14.50.
Okay.
I could be wrong.
And how many hours a week do you work typically?
It varies. It depends. Usually I get an 80-hour work week, but sometimes it's less, sometimes it's more.
And besides your taxes, what else gets deducted from your gross pay?
Give me that again, I'm sorry.
What is deducted besides federal income taxes and Medicare taxes from your check?
I'm not sure.
Do you have health insurance deductions?
I have health insurance through my job.
Okay, but that's for your, correct?
I'm sorry?
That's for your health insurance.
That's my health
Okay,
insurance.
you don't cover your daughter's and your employer's health insurance plan.
No, my employer provides my insurance for me only.
Okay. Do you have a retirement account there?
I do not.
Any other source of income?
No.
Has Mr. Martinez advised you that he had a shift schedule change in his place of employment?
He just recently told me that he would be working nights.
Okay. What is your objection to him receiving the girls on his days off instead of the Friday to Sunday that he's currently getting now?
Mr. Martinez doesn't follow the schedules for the curricular activities that the girls have. Usually the volleyball schedules, they're always up in the air. So they'll say, you know, who's available for practice. And since Mr. Martinez says that it's on his time and he should do what he can with the children on his time, he usually objects to going there, taking the girls to any practices.
So if he agrees on the record that he's going to comply with taking them to any extracurricular activities, do you have an objection to him getting the girls on his days off for June?
I prefer that the girls go to their curricular activities if Mr. Martinez can take them to all of their activities, and I don't see a problem.
Okay. So he's willing to state on the record that he'll take them. So you're okay with him receiving the girls?
Not unless he
Thurs-
agrees to going to, sorry, I spoke over you. Not
So-
unless he agrees to going to all practices for the children.
And I'm representing to you that if you notify him of any last minute changes on activities for the girls, he's committing to taking them when it's his possession dates.
I don't have to notify Mr. Martinez because Mr. Martinez has and always been on all group chats for the girls' sports activities. The only thing that he's not in, because I myself am not in also, is for the rec volleyball practices that have already been paid for the month. Those you have to attend on your own. There's no group chat. They're kind of like private practices.
Okay, so what is that, the rec activity?
That the recreation center on Hillside, the girls they have like a volleyball practice. I don't know how to explain it, but
Okay.
they're private practices for girls to improve their skills in volleyball.
And why is there no schedule for that?
Why are they on that
No
schedule?
set schedule?
Why is there a set
Is there a
schedule?
set schedule for that activity?
That's a set schedule.
Okay.
Yeah,
And you're saying that there's no group chat, it's just a schedule, correct?
the group chat is not a set schedule, not all the time. They're supposed to be it's only for Madison, the youngest, and
Okay.
it's supposed to be Fridays at 3 p.m. to 4, and times do change.
So if his days off are Thursday to Saturday, would you have an objection to him receiving the girls and having possession of the girls Thursday to 6 p.m. and to Saturday at 6 p.m. only for the month of June?
I would object if he's not able to take my children to attend these practices.
Right, but June just started, so that hasn't happened, correct? You don't
I'm
know if you don't know if he's gonna miss any in the future, correct?
What was that?
Are you in agreement to having the girls with Mr. Martinez on his days off? So that your girls can spend time with their father?
If Mr. Martinez takes the children,
And I'm telling you, as his attorney, he's willing to take the girls to any activities that are occurring on his possession dates.
I don't see a problem.
Okay.
there.
And for July, would you have an objection if his schedule changes for the month of July to have the girls with Mr. Martinez on his days off? He'll provide you notice as soon as he has his July work schedule.
I don't see why Mr. Martinez can't follow the schedule that's already set.
Because his schedule changed and he can't control that either. So that's why he's asking in good faith. He wants to spend time with the girls. He does not have his work schedule for July, but would you have an objection to him having the girls on his days off for the month of July?
Section says, in the attorney testifying on fact not in evidence.
Inaudible.
May I objection, facts not in evidence, Judge, she's testifying as to what her client has said, but there's no facts in evidence regarding any schedule.
Sustained, rephrase, or move on.
If Mr. Martinez has a different days off for the month of July, would you be opposed to him having the possession of the girls during those dates?
I'm not sure.
So if you don't have any problems with him having the girls on his days off in June, what would be your objection if those dates change for the month of July?
Objection, that calls for speculation, Judge. We don't have any firm dates that he just says any days. What specific dates? He doesn't even, or the facts elicited have not been specified.
Sustained.
What specific dates?
If when Mr. Martinez gives you his work schedule for July, what is your objection to him having the girls on whatever days off he is given in July, I'm sorry.
So if Mr. Martinez can give me a physical copy of his schedule of work, I can try working with Mr. Martinez. So as long as he's compliant and doesn't change his schedule often, because I have had several times that Mr. Martinez does not pick up his children at all. He'll tell me he can't pick them up on Friday, he'll pick them up Saturday morning. And then his times change constantly. So this is why I'm very opposed to agreeing with Mr. Martinez's schedule changes.
And so
Okay.
you don't, if he has schedule changes, you don't want to comply. You want to stay with the standard possession order with no concessions for his shift changes.
We can stay with the standard possession. I know it says on there that anybody that he trusts or a responsible adult can pick up the children. Mr. Martinez has not yet used that, and I've mentioned it to him several times. So I don't see why there's an issue with him picking up the children on his scheduled time.
Okay, so you don't agree to have him having the girls on his days off
For when?
for the month of July?
I don't know yet. We're not in July yet.
So you're claiming that adultery in this case, correct?
Correct.
When did you separate from Mr. Martinez?
June, I want to say June 8th. I don't have the paper in front of me, but it'll be 2 years on
Okay.
June 8th.
And on June 8th, 2024, what evidence did you have that he was committing adultery?
So no physical evidence, but Mr. Martinez had already been acting different. And you know, I got a Facebook, little people you may know, and I saw Ms. Terraza's picture. So I told him, who is she? And he said, oh, it's just an
And
acquaintance.
Judge, I'm going to object to the narrative. Like, witness can allow me to answer some questions. Ask
Sustained.
some questions.
Sustained. Let's hear the question.
So you mentioned you didn't have any physical evidence, correct?
No,
On June 8th. When
On
you
June-
separated,
on June 8th, yeah,
2024?
2 years ago.
Okay. And you said that you had a feeling, but it wasn't anything certain that he was committing any adultery.
Give me that again.
You had a gut feeling only, you felt that he may have been. You were speculating that he was committing
At that
adultery.
moment, yes.
Okay. And you didn't institute any type of divorce proceedings, correct?
No, Mr. Martinez said, what was the rush?
Okay. And the arrearage that is with the Attorney General's office, were receiving some Zelle payments from Mr. Martinez, correct? While during the time of separation,
Give me that again.
were you were getting Zelle payments from Mr. Martinez while you
Mr.
were
Martin-
separated?
Yes, Mr. Martinez sent me a payment so that I can pay for the house that I was still living in.
Okay. How many payments did he send you on Zelle?
I'm not sure. One?
Have you denied a request by Mr. Martinez for any different possession dates with his children?
Denied possession dates?
If he would needed a change, have you always denied those requests for a change in possession?
Not always,
But you have denied him changes.
for a reason, yes.
When, do you know when Mr. Martinez lost his employment from the Webb County Sheriff's Office?
I don't remember.
But he had been helping you pay for them, or had been paying for the mortgage at the home that you lived in prior to that, correct?
Our home.
Correct,
He
But
had
you were-
been,
but you were the one
he
living
had
there,
been
correct?
paying our home.
Correct.
Yes.
right. That was before the date of separation. That's right, after the date of separation and before he was terminated from the Webb County Sheriff's Office.
When was he terminated from the Webb County Sheriff's Office?
Well, I'll get to that with Mr. Martinez, but after he moved out on June 8th, 2024, which is your alleged date of separation, he began paying the monthly mortgage payment, correct?
It's because I'm not sure when he was terminated and if he was still giving payments
Okay.
then. Yeah, so I'm not
So
sure.
when did he start making payments for the mortgage?
He was paying for our home at the time, yes. I think he paid for June, July? I really don't remember.
And he paid them for whenever he was not living there, correct? You were the one that was using the home with the children.
Yes,
Okay.
with my children. Mhm.
Did he give you any other assistance through Zelle?
Sometimes he would help with costs for volleyball or basketball.
And you're aware that Mr. Martinez has another child that's older than your girls, correct?
Another child?
Yes,
Gabby, yes.
yes. And he also pays child support for that child, correct?
I'm not sure if he's paying child support right now.
Have you been using app Close to communicate with Mr. Martinez?
We were, and then Mr. Martinez was not sending any child support payments, so I wasn't able to afford it. So once I signed back on.
And are you in agreement to continue using app Close?
I notified Mr. Martinez that we should go back on app close, but he mentioned that there was no court order for it, so he denied continuing use of it
How have you been communicating with him?
through text.
And is it true that you have your daughters send Mr. Martinez their activity schedules instead of you communicating that to him?
No,
You haven't ever had your daughters send him their schedules? You
I
sure
don't
about
tell
that,
my
Ms.
daughter to send the
Salinas?
schedule.
I
My
didn't hear
daughter,
you.
go ahead.
You're telling the court here that you've never not communicated with Mr. Martinez and instead had your daughters communicate your request to him.
My daughter, one daughter,
Okay,
Madison, Penelope,
Mhm.
she sends it to her father.
okay. And Penelope is the older one?
Yes,
Okay. And would you agree to leave the children out of the conversations and have that communication between you and Mr. Martinez?
I hope so. Mr. Martinez did mention in a recent text that he would be notifying my
No, and I'm gonna
children.
object to non-responsive. I haven't asked a question.
Sustained.
When did you move out of the home, Miss?
September of
Of-
last year.
2025?
Yes,
Okay. Had you notified Mr. Martinez that you were gonna be moving out of the home?
I don't remember. I don't think right away.
Okay. How did he find out where you now lived with your daughters?
Give me that again.
How did he find out your new address?
I don't know.
Did you tell him?
No, not right away.
Okay. And you're aware that you have to notify him, correct, of those address changes if you move with your daughters?
Yes,
Are you strictly using Medicaid, Miss Salinas, for the children's medical care?
not strictly, no.
What
It
else? Sorry,
It has to be used.
but you're the one that enrolled them in Medicaid, correct?
I applied for it and they approved it. Yes.
When did you apply for it?
I applied for food stamps and Medicaid.
How long ago? I'm sorry.
I want to say last year.
So sometime in 2025?
I want to say so.
Okay. Were you aware that Mr. Martinez did have health insurance, dental and vision for the girls, his employer?
He had mentioned it to me,
Okay.
yes.
So once you receive that information, you agree you no longer need to place the child with Medicaid coverage, correct?
So Medicaid is only approved to low income. So I believe the only reason why they didn't approve me Medicaid at the beginning was because I was receiving child support payments. As soon as I stopped receiving child support payments, I reapplied and that's when they helped me. Now that I am receiving child support payments, I do have to report that. That's why I mentioned that.
Okay.
I believe this is my last month.
Right.
with-
And you agree that if they have to have the coverage through their father's health insurance, medical and vision, you were willing to continue with the coverage that he can provide them?
Yes.
Okay. I'll pass the witness, Your Honor.
Cross-examination, Mr. Castillo.
Ms. Salinas, during the pending divorce case here, did Mr. Martinez file any criminal complaints against you?
Yes.
What was the criminal complaint?
He was filing for identity theft.
And what facts, if any, did you learn about what his complaint was?
What, I'm sorry?
What was the complaint about? What was he complaining about?
The complaint was for our Spectrum account moving from our old home to my new apartment.
The Spectrum account during the pendency of this divorce has been under whose name?
The Spectrum account is under Mr. Martinez's name, and I was an authorized user.
And that's the reason that he filed a complaint?
Your Honor, cause for speculation, Ms. Salinas does not know the reason or what Mr. Martinez might have stated to the police department.
Here's the instruction. Don't guess. Don't make anything up. If you know the answer, you can give it. If you don't know the answer, you should just say that. Go ahead.
Did you have occasion to be interviewed by any police investigator? Did you have occasion to be interviewed by a police detective or investigator?
An investigator.
Do you recall his name?
No, not at the moment. Alcaraz.
Oh, I'm sorry. Investigator Alcaraz. Okay. What, if anything, did Mr. Alcaraz tell you about what the complaint was about?
Your Honor, I'm not object to hearsay. Mr. Investigator Alcaraz is not here to testify as to what was told regarding this investigation.
Responses to hearsay?
Judge, it's what, if anything, the officer told her about the complaint.
Your Honor, I think it's still hearsay that they should have brought in the investigator to directly testify about that.
So it's an out-of-court statement used to prove the truth of the matter asserted. Is there any exception?
Person sensing the exception, Judge, because he was there when she was told. The investigator came.
That would be her impression, not his statement. So that's overruled.
Okay, I'll ask something else, Judge. Did you learn, or have you learned whether that complaint still pending?
Believe so.
Okay. Now, you mentioned on questions by Ms. Soto that you saw some Facebook items regarding Mr. Martinez and another person, correct?
Yes.
And can you describe what you saw in Facebook?
I saw Mr. Martinez engaged to someone else. I also saw Mr. Martinez buy a new vehicle for someone else, which is Ms. Terraza's for her birthday.
Did you happen to see a Facebook posting with Mr. Martinez giving a engagement ring to Ms. Terrazas?
Yes.
And I'm gonna object to leading.
Well, the court heard the response. It was leading, so sustained, but it's on the record, Mr. Castillo.
I'll go ahead and withdraw it. I'll ask Mr. Martinez. In fact, I'll show the Facebook clip.
Very well.
I'll pass away this one.
Anything on redirect?
Briefly, Your Honor. Ms. Salinas, do you recall when you saw those Facebook posts?
No.
But you have been effectively separated from Mr. Martinez about 2 years now, correct?
Give me that again.
You've been effectively separated from Mr. Martinez for 2 years now, correct?
Yes, on June 8th.
That's all I have for Ms. Salinas.
Anything on recross?
Nothing else.
Ms. Salinas, you may step down. Ms. Soto, who, if anyone, is your next witness?
I'm going to call Mr. Jorge Martinez, Your Honor.
Mr. Martinez, please take a seat here on the witness stand. As you have a seat, Mr. Martinez, same instructions to you as with Ms. Salinas. Listen to the full question before you answer. The lawyers are likely to, they could object. If they object, just pause your answer. I'll let you know if you can answer. Ms. Soto, when you're ready.
Thank you, Your Honor. Mr. Martinez, where are you currently employed?
I'm currently employed with the Laredo Independent School District as a police officer.
And what is your base pay there, Mr. Martinez?
$24 an hour and change.
Do you get any overtime at that?
No, ma'am.
And so you work a 40-hour work week?
Yes, ma'am.
Are you currently providing health insurance, dental insurance, and vision insurance for your children?
Yes, ma'am.
And that gets automatically deducted from your paycheck?
Yes, ma'am. That's correct.
How long have you been with LISD Police Department?
I want to say 8 months, November
November of 2025?
2025. Yes, ma'am.
Prior to you being employed at the LISD Police Department, where had you been employed?
Shortly before that, I was part-time with Burlington.
Burlington stores?
Yes.
Okay. And previous to Burlington?
Previous to Burlington, I was with the Webb County Sheriff's Office.
And during our temporary orders hearing, you had disclosed to the court and testified the reason for your resignation, correct?
Correct.
What was your intent in resigning from the Webb County Sheriff's?
Basically, it was either termination or resignation.
How would a termination have affected your ability to maintain a law enforcement position?
It would have been very difficult as far as being hired in the position that I'm in right now.
Okay. After your resignation from the Webb County Sheriff's Office, did you attempt to be hired or apply to any other law enforcement agency?
Yes, ma'am.
Which ones?
I had applied with the U.S. Border Patrol, TABC, ICE, Constables, Precincts 1 and 2, Laredo Police Department as well, and UISD as well, and then LISD.
Okay. And did any of those facilities offer you a position?
Yes, LISD offered me the position.
Did any of the, besides LISD, did any of the other law enforcement entities you just listed offer you any job interviews?
Yes, I had interviews with U.S. Border Patrol and TABC.
Okay. And do you know why USBP did not offer you a position?
USBP stopped reaching out for me after the medical portion when they were looking at the background as far as like the child support that was still owed. So it was just, I'm assuming they didn't give me enough specifics, but I'm assuming it was because of, I guess, unreliability because of that.
Okay. And then what about the TABC?
TABC, the last thing that was told to me is out of everybody that was, they were trying to get reference from, when they were trying to attempt to contact Ms. Salinas, she was refusing to give any statements to them.
Okay. Would that position have paid you more than your LISD Police Department position?
Yes, ma'am.
Okay. Was any other reason provided to you besides Ms. Salinas' refusal to cooperate?
No, ma'am.
Mr. Martinez, you don't decide your schedule, correct, with LISD Police Department?
Correct.
When were you notified of the shift change for the month of June?
The last week of May, I want to say it was the 28th of May.
And so for the month, sorry, for the month of June, what days of the week do you work?
So I'm working starting Saturday midnight, which would be Sunday, through Wednesday. I get out Thursday at 8:30 in the morning.
And what is your request to the court regarding the June possession dates?
So I had requested to pick up the children Thursday afternoon, and then return them back Saturday afternoon.
And Thursday, what time would you, what, instead of afternoon, what, can you give the court a date, a
y-
time, I'm sorry,
Yes, I could do 6 p.m.
on Thursdays?
Thursday, 6 p.m.
And then what time would you be able to drop them off on Saturday?
Same Saturday, 6
Okay.
p.m.
And if the girls have any type of extracurricular activity, are you willing to take the girls to, so that they can attend those activities?
Yes, ma'am.
Do you have access to all their activity schedules?
So I'm on the group chats that were provided. The only schedule that I've seen so far would be the schedule that my daughter had provided to me for band camp,
Which daughter?
Penelope.
No, okay. But you don't have any opposition to taking the girls, correct?
No, it's as long it's my day off. I can abide by that.
And for the month of June, that's what we're discussing right now.
Correct.
You would have the girls, you're requesting that to have them on your days off, correct?
Correct.
So if they have an activity, you're willing to take them on those days off.
Correct.
When will you know your schedule for July?
The ending of June.
What would you request from the court regarding your visits in July?
Just the same. On my days off, I can do the same thing, 6 to 6. Those
Okay.
2 days or 3 days.
Okay. Are you going to have the same issue with a shift change in August 2026?
No, so come August, I will go back to regular school schedule.
Okay.
So I'll be off the weekends.
Okay. Have you had occasions where you've requested a change in possession dates from Mrs. Salinas?
Can you repeat that again? I'm sorry.
Have you requested possession date changes before from Mrs. Salinas?
Yes, ma'am.
And what has been her response? to your request?
She just basically says that she would feel comfortable following the court order.
Have you missed visits with your daughters because of her denial to address your shift schedule?
Yes, ma'am.
And do you think that that's in your child's best interest to not visit with you?
Not at all.
Mr. Martinez, have you applied recently to any other positions for employment?
No, ma'am.
Now, Mr. Martinez, Mrs. Salinas claims that you were committing adultery when you separated. Were you in a dating relationship with anyone?
No, ma'am. Not right away.
How long have you known Mrs. Terrazas?
I've known Mr. Rasas since towards the ending of December of 2021.
And how did you know her?
She was my dispatcher for
Okay.
Webb County Sheriff's Office.
When did you start dating Miss Terrazas? If you remember.
I
date?
want to say August of that month that I left.
Of the year.
Of
that
the
you
year, I'm
left.
sorry. Of the year that I left.
So it was August 2024.
Correct.
Was she the reason you left Mrs. Salinas, or the relationship with Miss Salinas?
No, ma'am.
Why did you leave the relationship with Miss Salinas?
It was just unbearable. I just did not want to be there anymore. I had already in the past tried to, and she would multiple times throw the girls at me, throwing me guilt trips on why I shouldn't leave.
And let's address the issue of you proposing marriage to Mrs. Terrazas.
Okay.
When did that happen?
This was last year, I think around June or July. I don't recall the date.
So it wasn't immediately after you left the home with Mrs.
No.
Salinas.
No, ma'am.
And after you proposed marriage, Ms. Salinas didn't file for divorce, correct?
No, ma'am.
And wasn't claiming any type of adultery provision in any type of petition at that time. She didn't file anything.
No, ma'am.
The vacation post that Ms. Salinas alluded to earlier during her testimony, when was that vacation post?
Which
With you
vac-
and Mr. Razas?
which vacation, ma'am?
Can we prompt 8:33 and 8:34?
Without objection, court staff will prompt.
What was the question on that, Ms. Soto?
The first page with 2 pages, Mr. Can you scroll down to 8:34 so we can also see the second page, please? So that exhibit is actually 2 photographs. Can we scroll back up to the first one?
I believe those are 2 separate dates, though.
Correct. So
Yes.
I'm gonna ask you about 8:33. Do you know what date that was posted?
I don't recall.
So it said it's her birthday week. What would have been her birthday week?
So September 10th is her birthday, so probably around that.
And was that 2025 or 2024?
No, I don't know. I don't recall, to be honest.
So in that one, you're calling her your future wife, correct?
Correct.
Were you already engaged at that time?
I believe so, yes.
Okay, so it would have been September 2025?
Correct.
Okay, so a year and 3 months after you left Mrs. Salinas' home?
Correct.
Can we scroll down to 8:34, please? Do you know an approximate date of that photograph, Mr. Martinez?
I don't.
Do you recognize where you're at?
I want to say yes. I believe that's a ranch.
But you don't have any idea of the date and time for that one?
No.
Okay. Have you ever made any admissions to Ms. Salinas that you committed adultery while your marriage was intact?
No, ma'am.
When you left the home, did you have a discussion with Ms. Salinas about why you were leaving the home?
Yes, ma'am.
And did she accuse you of adultery at that time?
No, ma'am.
B 211, please.
Court staff will prompt.
What is that document, Mr. Martinez?
That is my pay stub.
Can you see the check date on that?
2/19/26.
How often are you paid by the Laredo ISD Police Department?
I'm paid once a month.
And can you see your gross pay on that pay stub?
Can you point it to me? I can't really make it out.
May I do that, Your Honor?
Without objection, go ahead.
It's blurry from here, honestly.
Is there a screen right below you?
There's a screen here, yeah, not on, but
Ms. Flores, let's turn on that screen so that he can see. Is the screen now on?
yes, it's on.
Can you see it clearly?
Yes.
Ms. Soto?
Thank you, Your Honor. Do you see your gross pay for that month, Mr. Martinez?
Yes, ma'am.
What is it?
It is 3,832.75.
Does your pay change every month?
No, ma'am.
What is the charge there on that paycheck, on that pay stub for your health insurance?
For the health insurance, it is $592.84. For dental is $58.65. And vision $13.15.
And is that a family plan or is that only for your daughters?
It's a family plan.
So you would agree that we'd have to discount your share from that cost, correct?
Correct.
And that's gets deducted every single paycheck, right?
Correct.
And do you have any union dues with the LISD Police Department?
No, ma'am.
Are you requesting, and you have one other child, correct?
Correct.
And that other child is not of the marriage with Ms. Salinas, but a previous relationship, correct?
Correct.
And do you pay child support for that child?
Yes, ma'am.
And you would agree with me that the percentage for child support with 2 children before the court and 1 child outside of the court's jurisdiction is 22.50% of your net pay.
Correct.
Do you have any other source of income, Mr.
No, ma'am.
Martinez? And I showed you the amount for child support at $545.35, correct?
Correct.
And you don't have any objection to that amount based on the 22.55% of your net pay.
Correct. I don't have an objection.
And of course, with the understanding that you will continue to cover the girls for medical, dental, and vision.
Correct.
And you're aware that you have an arrearage, Mr. Martinez?
Yes, ma'am.
What is your request to the court as to how to pay an additional amount in order to start clearing that arrearage?
I can agree to $100 extra
Monthly?
monthly. Yes.
Was it your intent, Mr. Martinez, to deny or decrease your child support when you terminated your employment with Webb County Sheriff's?
No, ma'am, that was not my intent.
Have you provided any other type of informal assistance to your daughters?
Informal meaning,
Have your daughters asked you for funds, and have you made those funded those requests?
they haven't asked for me anything.
Okay. Are you have you assisted in paying for any of the extracurricular activities that they're in?
I have before, yes.
Okay. I'll pass the witness, Your Honor.
Cross-examination, Mr. Castillo.
Mr. Martinez, when did you start working with the Webb County Sheriff's Department?
With the Webb County Sheriff's, January of 2014.
And what was your title at that time?
I was a correctional officer.
Okay. And how long did you remain as a correctional officer?
I want to say for about maybe 2 years,
Okay.
give or take.
And after that, were you promoted?
I was given the opportunity to attend the police academy and becoming a peace officer.
So, but were you promoted? Yes or no?
I became a peace officer. It's not a promotion.
Okay. And that was the change to what? What position?
To a police officer, deputy.
To a sergeant?
No, to a deputy. Graduating from the police academy, you become a deputy.
Were you at time a corporal and sergeant?
After a few years after that, yes.
Okay. And that was for about 2 years thereafter, correct?
Correct.
And after sergeant, were you demoted back to deputy?
Correct.
And when were you demoted? Was it like early 2024?
I believe it was early 2024. I can't give you a date. I'd be lying.
Would March or April 2024 be accurate?
Maybe March, April, around March, April, yes.
Okay. Why were you demoted?
I have an ongoing investigation on that, so I'm going to plead the fifth on that.
How much were you earning at that time?
At the time, before the demotion or after the demotion?
Before the demotion?
Before the demotion, $39 an hour.
And after the demotion?
35.
35 per hour, okay? So you're pleading the fifth?
Yes, sir.
Is that on the advice of your counsel or on your own?
Both. It is, like I said, it is an ongoing investigation, so do not want to self-incriminate myself.
So you're not gonna answer it first.
When it pertains to that case, no.
And what after you were demoted, then you continued working, let me ask you, what that was in 2024?
Correct.
Okay. And you remained there until what time?
Until July of 2025.
July 2025.
Correct.
And you left the employment on July 2025 with the Webb County Sheriff's Department, correct?
I was forced to resign, yes, due to political reasons, and then the case that I'm mentioned.
Were you terminated?
That was an option. They were going to terminate me, but they offered me the resignation.
What was the reason for them telling you we will terminate you or you can resign?
Again, I cannot get into that. I'm gonna plead the fifth on that one due to the open investigation.
Are you pleading the fifth?
Yes, sir.
Okay. And how much were you earning at that time?
35 an hour.
35 an hour. And today you're earning how much? 14 an hour?
24.
24, okay. Okay, now, earlier, you testified that you had left the home where you and Ms. Salinas were residing around 2024?
Correct.
And you didn't file for divorce at that time.
Neither did she.
Right. So if you did not want to be in the relationship, why did you not file for divorce?
Because honestly, it was nothing that we thought about. We already knew not only ourselves, but our family members, friends, that the relationship had ended. So that didn't come to mind.
So earlier you testified that you expected Ms. Salinas to file for divorce.
Oh, I never said I expected her.
Oh.
Neither of us did.
Okay, so you're not blaming her for not filing, right?
I'm not blaming her.
But you did, you have admitted to committing adultery, correct?
No, I have not.
Have you had encounters prior to filing for divorce with anybody?
Again, we are separated and I am engaged now.
That's not the question, Mr. Martinez.
Mhm.
Did you engage in intercourse with anybody prior to filing for divorce? Well, after you separated?
After I separated, when I began a new relationship, yes.
And with whom?
With Mr. Razas.
When you moved out of the house,
Mhm.
did you advise Ms. Salinas of the change of address where you were living?
I don't recall I did. It's irrelevant.
Then you expect her and the children to know where you were living?
I mean, she could have asked me. I mean, I'm more than sure she knew where I was. I did stay at my cousin's house and at my parents' house as well.
So you never gave her your address, right?
No, I mean, she knew the addresses of where I was.
And you knew hers, right?
Correct.
Yeah.
Up until she moved, I had no idea she moved. I had no idea where she moved to.
Okay. And in July 2025 is when you decided to resign from Webb County, correct?
I did not decide. I was forced to.
Well, you resigned, right?
Correct.
Whether it was forced or not, you resigned.
I was
right?
forced, yes.
Did you go to the Workforce Commission to look for employment?
No, I did not.
At that time, did you know you owed child support?
At that time, did I know I owed child support?
Yes, sir.
No, I did not. Because I left in July and the last child support payment was given in July.
And in August, did you pay child support?
During my time frame until I was working, I gave what I could. When I began working at Burlington, which was $12 an hour, maybe 14 hours a work week or biweekly. So I tried to give what I can. It was obviously not as close as what the order.
But Mr.
Pertain to.
Martinez, when you resigned from the Webb County Sheriff's Department,
Mhm.
you had a retirement account, is that correct?
Correct.
At that time, you withdrew the full amount, correct?
Correct. Correct.
How much was that?
If I remember correctly, it was around 40,000.
49,000.
40. A little over 40. I don't remember the exact number.
Actually, isn't it true that $47,965.14 was deposited in your Chase account by the retirement system?
If that's the number you have, then yes. Again, like I don't recall the correct number.
July 22, 2025, right?
Correct. Yes.
Okay. And then on August 12, 2025, you filed for divorce
Mhm.
in this case, right?
Well, I didn't file for divorce with that intention. We filed to try to sell the house, which she was with Miss Salinas was not willing to sell on our own. She continue telling me that, hey, we have to go through court instead. So that is why we filed. That it came through divorce court. I mean, again, my intention was not let's go file for the divorce, because I did not think of the divorce.
On, so you kept 100% of the retirement, right?
I used it, yes, because I was unemployed.
Do you recall when we had that hearing on October 9, 2025 last year, when I asked you, how did you pay your attorney?
Mm-hmm. Yes, sir.
And you said, well, I didn't have money, I have to borrow.
For Ms. Soto, yes.
But why would you have to borrow if you had just received $47,965.14?
Because I had to retain an attorney for a federal case.
Who was that attorney?
Mr. Almanza,
And how much did you pay?
about $20,000 to retain him.
So you paid $20,000. Have you paid any other amounts?
To Mr. Almanza, no. To that attorney, no.
Okay. Have you paid, other than the 20,000, you also pay how much to Ms. Soto?
Ms. Soto, I believe it was 4,000.
But you said at that hearing that you had to borrow money.
Correct.
What, again, if you had 47,000 and you paid 20,000, why did you have to borrow money?
Because I didn't have the money. Again, I was unemployed. I have a cost of living. I'm paying bills. I'm paying debts that I had occurred when I was with Ms. Salinas. I mean, the list goes on and on.
But did you understand that half of that money belonged to Ms. Salinas?
No,
You didn't.
no, I didn't.
You never told her I took out my retirement.
No, I did not.
And at that time, you owe child support, right?
At what
That's an
time?
answer, Your Honor, objection has been answered. He's already stated he did not.
Okay. After that, while you were unemployed, looking for employment, you still had at least $27,000 if you pay 20,000
Mhm.
to that attorney, correct?
Correct.
And you didn't pay child support to bring you current, correct?
Correct.
So what happened to the
So you,
$27,000 that were still out there? If you gave 20,000 to one attorney, you still have 20,000, 27,000. What happened to those 27,000?
you have to also keep in mind that the back pay that I have through child support, I was paying your client, and I have the Zelle receipts stating child support. It's not my fault that when the court put the order, that she refused to sign that I had paid her up until the order was paid or put.
But that was used for payment of the house, don't you recall?
Regardless what she decides to pay, the intent and the receipt says child support on the Zelle.
But weren't you told by the Attorney General's office that you had to comply with the rules, that you had to not contribute on the side, but file it with the Attorney General's office to be forwarded to Ms. Salinas?
Well, no, because the Attorney General told me that because there is a civil case, which is this right now, in place, that they cannot make any adjustments or anything until this is settled. That is what the Attorney General told me.
Now, you bought a ring for Ms. Terrazas, correct?
Yes.
How much did you pay for that ring?
While I was still working at the Webb County Sheriff's Office, yes.
And how much did you pay?
I don't recall. I don't recall.
And at that time, you had not filed for divorce.
Correct.
So you paid how much? You don't recall?
I don't recall the exact amount, no.
But you were married at that time and you went ahead and
I was separated.
Well, you had not been divorced, right?
Correct.
Whatever you earned from the sheriff's department wages, you used to buy the ring, correct?
Correct.
And that was community property, right? It belonged to both of you.
I mean, I don't see it like that, but okay.
What else did you buy, Mr. Otto?
I don't know. I don't keep track of what I buy and what I don't buy.
Give me a ballpark estimate.
I
How
don't,
much
I'm not gonna be throwing numbers I'm not confident with.
did you pay for down payment on a car?
Yes, I did.
Like how much?
I believe it was 2,000,
So you paid Mr. Asas to buy a car
correct?
prior to filing the divorce.
Right.
Mhm. And where did you get the $2,000?
So I also have, I'm also a collector of novelty things. So I did sell a lot of my things to come up with money,
Okay.
things that belong to me, my property.
And how much did you get out of selling those novelty items?
Don't remember.
Can you give me an estimate? $10,000?
Oh no, I wish.
5,000?
I wish. I want to say, if anything, maybe close to 1,600, 1,700.
You did not give any of that money to Ms. Palini, correct?
No,
What else did you pay Mr. Asas mortgage at her house?
I pay bills at the house that I live at. Yeah, so I do help pay mortgage. I do help pay electric bills, food, my responsibility.
Prior to the divorce, you were paying per mortgage.
After our separation, yes.
How much per month were you paying?
Depends on what, well, depends on what I was able to afford.
You were not paying your mortgage at the house where you and Miss Salinas lived, but you were paying Mrs.
Well, no,
Terrazas.
I was no longer employed at the Webb County Sheriff's Office.
But you were using money from the retirement account.
Not for, obviously, yes, because I'm not freeloading. I have things that I have to also contribute.
So out of am I correct to say that you owe around $6,000 to $7,000 in arrearage?
I believe so.
You only want to pay $100 per month on that arrearage?
Well, I mean, based on what I make, I mean, I'm no longer working at the sheriff's office.
Didn't you think before you spent those extra $27,000 that you had to pay child support?
Again, I had paid the child support up until the order went through. That I have back pay because your client did not want to sign that I paid. That's not my fault.
You could have paid those $7,000 in
But
arrearage if you had not spent them on Ms. Terrazas, correct?
there wouldn't have been a courage if she would have signed the papers that I had been paying her.
But forget about those.
It's facts.
Well, forget about those facts. Go with only what you were obligated to pay. Okay.
Which I did. I was making payments. That the child support does not take them into consideration because your client did not sign saying that I paid those. I mean, I sent the copy to Ms. Soto. I'm more than sure she can provide that.
Now, you said you had borrowed $4,000 from your in-law in October 2025 at the hearing, remember?
Correct.
Okay. Did you ever provide us evidence of that agreement?
I don't believe I did.
So you really didn't borrow. You had the money to file a lawsuit, correct? You misrepresented that to the court, correct?
No, I did not.
Again, you said you had to borrow money because you didn't have any money. So you borrowed from your in-law, Ms. Terraza's family.
Correct.
Correct? Have you repaid that money?
No,
Do you have any document that shows?
I don't have documents on me.
Now, we also asked in discovery, Mr. Martinez, for you to produce your personnel file with the Webb County Sheriff's Department. You invoked your Fifth Amendment right, correct?
Correct.
So how would we know those matters about your position, your salary, facts like that without that evidence?
I mean, I'm more than sure open records, if you yourself can go and request, if they're able to give that to you, I'm more than sure they can.
But you refuse to produce them.
Correct, because
invoking the Fifth Amendment.
Because I'm not going to self-incriminate myself with an open case that I have with the feds.
And that would include the amount of that you were getting extra bonuses and everything, correct? He
What
would-
bonuses?
At the sheriff's department.
I never got bonuses at the sheriff's office.
So, but we don't know until we looked at them, right?
Mm.
All right. But you're invoking the fifth.
Yes, sir.
How certain are you, Mr. Martinez, that you will be able to take your children to their activities on this new schedule that you're proposing for June? If they miss one class, do you understand that that affects them a lot?
I completely understand. And it's my days off, so I am able to.
There were times after you filed this divorce that you did not pick up your children on Friday, for example, and return them on Sunday because you didn't give a reason. You said, I cannot, I'm not going to. Is that correct?
I always explain that I couldn't due to work reasons.
Or you were out of town for something else, correct? Did you go to New Braunfels one time and say, I can't go pick them up because I have to go out of town?
Oh, of course, yes. I mean that there's nothing wrong with, hey, if I had plans to do something,
But
and that's why I would ask your client, can I pick them up the following weekend? But instead of helping me out,
those were social events with Mr. Rasmus, right?
correct,
And she has two children.
correct.
Did the children go with you both?
Not always they don't.
But on that New Braunfels trip they did.
No, they didn't.
Oh, so who went?
Just myself and Mr. Rasmus.
Okay. So you forego picking up your children when it was your turn to go with Mr. Rasmus somewhere.
I don't see a problem with that. It would be an issue if I was doing that every single time that it's my time.
What guarantee can you give the court that you will pick up your children on this Zoom schedule that you're requesting, that they're not going to be affected? Right now, they're going through their extracurricular activities. It's required by the schools. And if they miss, they can be kicked out of the team.
I mean, I am under oath and I'm stating that I will abide by that. I don't know what else you would want me to tell you.
So if you miss one time, will you agree that agreement is off?
If I miss one time, I'm agreeing that
One time to pick them up on time and take them to all the activities?
I'm not a fortune teller either. If there's an emergency that I cannot take them, that's a different story. But I'm letting you know that I'm gonna abide by the schedule that's being provided to me because it's my days off.
What arrangements do you have for anyone to assist you in meeting the two children's schedule in June? Do you have any?
Can you ask me that again?
What arrangements have you made with anyone to take your children to the different activities during the day?
Well, I haven't made any arrangements because I haven't needed to take them. June just started.
But who do you have, if any, right now to tell us that would be helping you get all these activities with your children?
I don't need help with anyone. I can do that on my own.
You gotta pick up one at 8 in the morning, and then the other one at 10, one at 3, one at 9.
Mhm.
Do you know how it's being handled right now?
I'm sorry?
Do you know how the children's attendance at these activities are being handled right now?
Right now, no, I don't.
Have you inquired?
Like I said, the only schedule that I've seen right now is the schedule of my daughter for band.
But you don't know the logistics of getting everything organized, but they don't miss a single activity.
Well, no, because this was not an issue until right now. So I'm obviously going to have to plan something.
And for July, you don't know at all because that was
Correct.
speculation, right?
July, we don't know because our supervisors do not have the schedules ready to go.
Okay. Now, did you during this divorce, go to the police department and file a complaint against the Salinas?
Yes, I did.
And, when was that?
I don't know the date, to be honest,
And what was the criminal complaint you filed?
for identity theft.
And what was the claim of identity theft that you alleged?
So the sole purpose that she used my name, she closed out the account that we had at the Conroe Street home and reopened it in her new apartment using my name and information. So that is the reason under penal code, that's identity theft, which is why I filed with the police department.
But the account at all times was under your name. But
Not at all times, because I actually went to go speak to Spectrum and they showed me both accounts had two different account numbers, which then states that the only reason why there's an account number that's different is because it was closed and reopened. Because if it was just a transfer of place, the account number would have stayed the same.
Mr. Martin, why did you not then come to this court to complain in this court instead of filing a criminal police report complaint?
Because that is my right. It is my right to file any criminal complaint when it has to do with my identity. Nowhere in the law does it state that I have to come and complain civilly.
When you filed this divorce, were you apprised of the rule governing the parties in the divorce?
Meaning?
Were you? Yes or no?
No, well, can you repeat it?
Calls for a legal opinion. If he can show him that the request or the document he's talking about so that he can refer to that.
Sustained.
Were you ever, did anybody give you advice to go file a police complaint?
No, sir.
Did you know that it would hurt Ms. Salinas when you did that?
Again, I'm not taking consideration people's feelings. It is clear in black and white there on penal code. So I did file for charges on the identity theft because I did have the elements met, which is why the investigator took it.
You're familiar with the penal code?
I'm very familiar with it. Yes, I'm a police officer.
Okay, are you familiar with adultery?
Yes, I do.
Have you committed adultery under the penal code?
No, sir.
You have not?
No.
What's the definition of adultery under the penal code?
While being married.
Have you had sex while being married?
When we're separated, yes. We have already established that we came to a conclusion that we both agreed that we were separated, no longer together.
Mr. Castillo can put the microphone closer to him. Thank you.
Thank you. Pass the witness, please.
Redirect.
Yes, Your Honor. Mr. Martinez, you're testified already that your retirement withdrawal was about 47,000, correct?
Correct.
Half of that would have been about 26,000, more or less.
Yes, ma'am.
And your sales proceeds from the home were 28,000,
Correct.
and you've already agreed to give that to Mrs. Salinas, correct?
That is correct.
What was your reasoning for giving her that sales proceeds in totality?
Just to not prolong this anymore.
Okay. And that would constitute her half of the retirement withdrawal, correct?
Correct.
And you were asked again, Mr. Martinez, regarding adultery. And you've conceded that you've had relations with Mrs. Terrazas after your date of separation, correct?
That is correct.
That did not happen while your marriage was intact.
No, ma'am.
And you've already testified before the court, and that's not the reason why you separated from Mrs. Salinas.
That is correct.
That did not cause the breakup of this marriage.
No, ma'am.
Has Mrs. Salinas ever told you that you cheated on her after you got engaged to Mrs. Terrazas?
I want to say she did mention it.
But only after you got engaged, correct?
Correct.
And at that point, you had been separated for over a year from Mrs. Salinas, correct?
Yes, correct.
After you paid Mr. Almaraz and you paid my services, were you still assisting in paying any household expenses at the home that you once shared with Ms. Salinas?
Yes, ma'am. I did have to pay for the repairs needed in order to sell the house.
Did she assist in paying any of those repairs?
No, ma'am.
Did she assist in getting that property ready to be sold?
No, ma'am.
How long did it take you to get that property cleaned and repaired?
Given the time frame, it did take me about 2 weeks, give or take.
And you had to do that yourself, correct?
Yes.
Did she provide any assistance, physical assistance?
No, ma'am.
And once again, you're not requesting any type of funds or reimbursement for that?
No, I'm not.
And you've already agreed to give her the entirety of the sales proceeds, correct?
Correct.
Have you had occasion to ask Ms. Salinas, Mr. Martinez, to allow somebody else to pick up the children?
Have I asked her? No, I have not.
Do you have anybody available to you, not just for the month of June, but throughout your possession schedule?
Yes, I do.
And who would those persons be?
It would be Mr. Rosas or even my mom.
And you understand that that's an option to you, correct?
Yes.
Do they both drive?
Yes.
Your mom is licensed?
Yes, ma'am.
That's a witness, Your Honor.
Was redirect. Anything on recross?
A couple questions, Judge. Mr. Martinez,
Yes, sir.
you realize that Ms. Salinas did go clean up the house before it was sold, correct?
No, when I was actually allowed to return back to the home.
No, I'm asking you, not you, I'm asking you. Ms. Salinas went in and cleaned the house, correct?
Not that I'm aware of.
When you left the house, you left a lot of your clothing in the house, right?
Correct.
Why did you leave the clothing in the house?
Because I was told not to go back.
You could have, you had no intent to leave, right?
Your Honor, he's already answered the question. He wasn't allowed to go back. Objection asked and answered.
Understand you can rephrase or ask a different question.
Why did you not go get some court authority to remove your thing?
Well, to my belief, I had assumed that I had removed everything. What was left behind was obviously not needed because I didn't think about it.
And before the house got sold, you took some items in the house, right?
The only thing that I was allowed to take, which Ms. Salinas agreed to, was one television and one of the couches that was there. Everything else, the clothes that was there was obviously not needed. I threw out in the trash can up in front.
Okay. That's with you.
Any other questions?
No, Your Honor.
You may step down.
Thank you, sir.
That was still your witness. Any other witnesses, Ms. Soto?
I don't have any other witnesses, Your Honor.
Any witnesses, Mr. Castillo?
No, Judge, I have one, but I think I will not need her. He's already admitted what I needed to get from her.
All right, so no other witnesses, no other witnesses. We stand at ease for just a few minutes and then we'll go straight into closing. Stand by. Court is back in session. We are once again on the record. This is Martinez versus Salinas, cause number 2025 FLA 1199C3. When last we left off, the court had heard evidence and testimony, or testimony really from each of the parties. We will now go into closing arguments. Ms. Soto, Mr. Castillo, the court is going to give you a few minutes. What the court is asking that you do is tell the court what your client is requesting and how the testimony supports that request and what the law says should happen in those situations. Ms. Soto, when you're ready, you may proceed.
Yes, Your Honor. The first request that my client makes is a denial of a finding of adultery and rule that the marriage ended because of irreconcilable differences with no expectation of reconciliation. At the time of separation, Mrs. Salinas did not have any evidence of any relationship, extramarital relationship between Mr. Martinez and anybody. She said she had a gut feeling, and referenced Facebook posts. Those Facebook posts were not dated as of the date of separation. They were in fact dated more than a year after the date of separation. Neither party had effectuated or began a divorce proceeding. So that was absolutely not the reason for this marriage ending. So for those reasons, we want the court to rule a denial of that finding of adultery. And Your Honor, as far as the June and July schedule changes, for June, my client does have the days off for Thursday through Saturday. He's requesting the court to allow, in the best interest of the children, to allow him to pick up the daughters Thursdays, the first, third, and fifth Thursdays of the month from 6 p.m. to Saturday at 6 p.m. and is willing to pick up and drop off at mother's home. He's already stated on the record, we're willing to comply with every single activity that the girls have. He's going to keep abreast of any activity, any scheduling changes so that he can effectuate the girls' attendance. They're his days off, so he doesn't have any other commitments to attend to besides the girls. If an emergency should arise, he can rely on Mr. Razas or his mom, paternal grandmother, to assist him if he needs to be in two places at one time, if the girls have a conflict with their schedules. So we're asking that the court consider for the month of June 2026 that he be allowed that change. For the month of July, he is expected to also have a change in his days off in shift work. He wants the court to order the parties that Mr. Martinez has to provide that new work schedule for July 2026 to Mrs. Salinas, and so that she's aware of what days off he has. So the first day off that he has, he would request that the court allow him to pick up the girls at 6 p.m. And then 2 days after that, for his 3-day visit, he will drop off at mom's house, also at 6 p.m. It is correct that we don't know what those July dates are because he has not been provided those, but it is in the best interest of the girls to have a continuing relationship with their father as well. And the issue of child support, Your Honor, we were before the court in October for temporary orders. At that time, the court did leave the child support at the amount that was originally established by the Attorney General's office. He has testified before Your Honor all of the applications that he submitted. He's also mentioned to the court that the reason why he accepted or took a resignation rather than being terminated is because if he was terminated, there's no possible way that he could have continued a law enforcement career. They would have immediately not even entertained an interview or the application process. He did state, however, that he took the resignation and made several applications to including Border Patrol, TABC, ICE, Constable Precinct 1 and 2, Laredo Police Department, UISD Police Department, and LISD Police Department. Out of those facilities or those entities, only 3 followed up with him. Border Patrol denied because at that time he had some issues regarding, of course, the ongoing investigation. And because the child support issue creates a reliability issue for that federal entity. TABC, he testified that they were interested. They asked for references. The only reference that they couldn't get a hold of was Mrs. Salinas. And he was denied any further processing because that reference that they needed to speak to did not comply. He took the only job that he was able to take in his chosen field, which is law enforcement. Prior to that, he had only been able to get employment at Burlington stores, not obviously acting as a law enforcement. So he has had some reduction, Your Honor, but at the time that he was terminated or demoted, he was making $35 an hour. He's at $24 an hour now. He stated under oath there were no bonuses, no type of incentive pay at the sheriff's office, but he was asked the court to allow him to continue paying child support for the girls in the amount as previously stated, which is $545.35 based on 22.50%, which is the applicable guideline range percentage. His base pay is $3,832.75, Judge. He is covering medical, dental, and vision for the girls, which can get discounted. And of course, after the reduction of the Medicare, federal taxes, his net pay is $2,423.78. And of course, we're not discounting the fact that he is paying child support for another child. For those reasons, Your Honor, because his intent was never to not pay child support or to decrease his ability to pay child support, we're asking the court to order that he pay $545.35 in child support. He's aware that he has arrears. For the arrearage, Your Honor, he's willing to pay, or he's requesting that he be ordered to pay $100 in addition to his monthly child support obligation. And of course, Your Honor, we are requesting that this is also in light of the evidence that was presented. He is able to provide that child support. It would also assist him in reestablishing, clearing his arrearage, and possibly getting a better employment and not having that mark on his record. And of course, we're hoping that that ongoing investigation will end soon so that it'll allow him to continue to get better employment. He took the best job offer that he had at the time. He in no way was he trying to decline paying Mrs. Salinas her fair share of what the child support should be. And while the intent is not mandatory, Judge, it does go into what the family code requires, that the court can take the intent into consideration. His intent in taking a resignation in no way meant that he was trying to do that to decrease his ability to earn the income. And he's also had a considerable reduction in pay that he was not expecting, but he took that in hopes of being able to, and in the future, be allowed to get better employment with his chosen field, which is law enforcement. So for those reasons, Judge, we're asking that the court set the amount of child support at the amount that we read into the record, and the arrearage back pay at the amount that we read into the record of $100.
Closing, Mr. Castillo.
Judge, on issue number one, adultery, he admitted on the stand that he has committed adultery. Also, Judge, on the October 9, 2025 hearing in this case, a transcript of which is on file with the court at A158 to A215, he admits also that he committed adultery. So it's not only today, but also in October 9, 2025. He did not change that testimony. The record is clear. He admitted it. Number two, Judge, the June-July schedule issue, he could not, Mr. Martinez was not able to confirm that he would keep all the strict hours for the girls. And our concern is they're already in the programs, they're already scheduled. There's no breakdown in that. If Mr. Martinez fails in one of those pickup of the girls or taking them different places, then what the ones that suffer are the little child, the two girls, in fact. So he was not, he could not guarantee, Judge, and he did not have any times for July. So maybe for June, the court could allow something, but with conditions, Judge, that in the event that he fails, that immediately that terminates. In addition, Judge, if the court allows the June schedule as they want, then he also needs to provide all the snacks that are required, all the extras that are required. They didn't go through that in court, but they do require snacks to be taken to different activities. With that, perhaps June would be okay. Now, July, it's up in the air. He doesn't know. So we don't know how to proceed on that. So June, perhaps okay. Number three is the child support. And we're claiming, Judge, underemployment. And that's what the court found October 9, 2025. The same information that he provided today is the same information that was given to the court. And again, the court has the transcript at A158 to A215. He had monies to pay arrearages, Judge. He got $47,000. Even if he says I paid $20,000 to this attorney, he's still $27,000 and cannot identify where the money went. And now he's saying, well, I'm going to pay them what's required plus $100 per month. $100 to pay the arrearages of estimated 6,000 to 7,000. I mean, that's going to take 6 years at that rate. 100, that's about 6 years to come current on the arrearages only. And then, so we're asking Judge to, there's not enough, no evidence provided, just like in October 9, 2025, to justify what he wants. He's underemployed. He decided to resign. He wouldn't give us the information we requested. Even here today, he pled the fifth again. The judge heard that October 9, 2025. And he continued in interrogatories, which are filed in this case. He also pled the fifth. So without that, there's a presumption that he is underemployed. I asked him how much he got at that time. It was $45 versus 35 now. So he can obtain some other employment that would be at the same level as his employment with the Webb County Sheriff's Department. And as far as the arrearage, again, Judge, that's wasting of community property. When he gets 47,000, doesn't give it to the spouse, but he did pay for the partner's living expenses, utilities, a car payment, mortgage payments. So, I mean, he can get the partner perhaps to contribute back, and he has assets, and he's not paying apparently household expenses. There was no evidence that he has to pay X amount per month. So he's living free at the other house. There's no evidence that he has to pay mortgage payments. There's no evidence that he pays utility or other costs for that household. So we're asking that everything remained intact, just like in October 2025 when the court found underemployment. And the other item, Judge, is the transfer of that Spectrum account that he arranged to go by and just sign off so that Mrs. Martinez, Ms. Salinas can have the account under her name. That's the only requirement.
Judge, we had already read that into the record as agreed to.
And I think those are the only issues, Judge. And I don't think there's anything else. Everything else was agreed upon. Well, one last thing, that even if you use their figure of based on their payment or salary that he gets, the gross runs $3,600. According to the Office of the Attorney General guidelines, for a employed person, $3,600, the net monthly would be $3,074, which is $691 at 22.5%. If you multiply that by 0.225, that's $691, not $545, using the chart provided by the Attorney General.
All right, let me ask the lawyer some questions to
Yes.
crystallize your positions. And I'll start off with the last thing posed by Mr. Castillo, and then I'll ask Ms. Soto for the follow-up. Mr. Castillo, so under your client's calculation of child support, your client's position is that it should be $691 per month?
That's using the Attorney General guidelines, Judge. Unless the court finds underemployment, then the $1,093 that was paid before the divorce,
And 691 beginning when?
that would be well, the first month after the order is signed here, the final judgment.
So you're asking July the 1st?
Yes, approximately, that's correct. Whatever amount to be July.
Follow up with you, Ms. Soto, your client is requesting 540,
545, Your Honor.
545, 535 beginning.
June 1st, Your Honor, because we're here before the court. And he has until the end of the month to clear that. So we would ask that it be June 1st, 2026. And I would like to point out to the court that Mr. Castillo's computation isn't taking into account that he's paying medical support, dental and vision. So he is allowed a deduction to reduce that amount from his net pay under the family code.
Crystallize, and I think these were your exhibits. They're not in evidence, but the court did see them and there was no objection. Ms. Soto, if the court recalls, and I was looking at my notes and I was paying attention, but I didn't write in, I don't recall the
Pay stub?
no, the Facebook pictures were taken summer 2025.
They were 8:33 and 8:34, Judge. For 8:33, that was a Facebook post of the birthday.
8:33?
8:33. It was Mrs.
The
Salinas'
date.
exhibits.
The date. Oh,
And it was during my client testified that it would have been the week of September 10th, 2025. And then for the 8:34 photograph, there was no date and time, and he couldn't remember when it was taken. 8:34 was a photograph of Mrs. Terrazas with Mr. Martinez, I'm sorry.
and remind the court he testified. What was his testimony as to his move out date? June 8th, 2024. I guess, Ms. Soto, crystallize for the court. I know your client testified as to his personal belief, and I understand that. I completely understand that. But the issue on adultery, what is the difference, if any, a distinction in law between date of separation and cause for divorce? He seems to make a distinction. Is there a distinction in the law?
Right, I believe it does because it has to be the reason for the breakup of the marriage. And the breakup of the marriage was irreconcilable differences that was not caused by the adultery or with somebody while you're still married. So he admitted that he had relations with somebody outside of his spouse when he was still legally married. There was no
The
divorce on
cause,
file.
though, where is that in the law? I've heard it.
Yeah.
And I've heard it here on the stand again today, and I was looking for it as it was being testified to. I can't. I looked at the cases cited in O'Connor's, I looked at the statute, I looked at the family code, I looked at 6.0003. If either counsel can crystallize the finding of adultery and whether the law makes a distinction between separation and cause, or just occurrence.
1 second, Judge.
And I'm allowing both to respond to that question, since there's a difference of opinion.
Sure, and I did review on the family code annotated sections that the court, I'm assuming you looked at the same annotations. So there is proof, there is case law that the court can review. It does state that it does not make a distinction for parties that have already separated. The court may still consider, doesn't say shall, but it states may still consider. And that's Escalante versus Escalante 632 Southwest 3rd 573, Judge, out of El Paso in 2020. We would ask the court, since it does not require, that the court may consider denying because of the lapse of time between the date of separation and the beginning of this relationship.
Any response, Mr. Castillo?
That's what the Escalante case says. Judge, there's also the case cited of Gurgis versus Gurgis. The adultery means the voluntary force of a married person with one not the spouse, not limited to an action committed before the parties separated. So, and it can be shown by direct or circumstantial evidence, and here the evidence was direct. He admitted. It's not that there's a suggestion, it's that he admitted. While still married, he had a relationship with Ms. Terraza. And in fact, Judge, when he pled the fifth, that's what I was trying to get him, because the reason for termination and demotion, I think, go to the fact that he was having a relationship with Ms. Terraza while employed with the Webb County Sheriff's Department during his hours of employment at the Webb County Sheriff's Department. But since he pled the fifth, he didn't provide us the personnel file. So there's a presumption when you invoke the fifth that there is truth to what is being alleged.
And Judge, my client has an absolute right to plead the Fifth Amendment. He does have that pending investigation. He doesn't have to answer them. He has the right under the Fifth Amendment to stay silent. That's what he's doing. He was not in a relationship with Mrs. Terraza. The evidence was that that happened afterwards. So that had nothing to do with Mrs. Terraza's. It was solely only for that investigation, and he shouldn't have to be penalized or punished or things inferred when there's no evidence before the court that that's why he's being investigated.
There's no evidence because he invoked the fifth.
Which he has a right to do.
But there's a presumption.
The US Constitution says he has an absolute right to stay silent. That's what he did.
But invoking the fifth rises to a presumption that it did happen. And it's rebuttable, and they did not rebut it. In fact, he refuses to answer the question.
Your Honor, to appease the court and Mr. Castillo, he did just mention that it was a federal investigation. I don't think the federal system is going to concern themselves with somebody having relations at the Webb County Sheriff's Office. Had nothing to do with Mr. Razas.
I don't, but so folks, so we're all on the same page. I don't find any fault for invoking any rights. The only thing that concerns me is that I have to make a decision in a vacuum, and that's okay. I just won't guess, speculate, or try to figure out what may or may not have happened. I just need to figure out what my universe of evidence is, and then just based it on that without guessing as to what. I mean, maybe not. I don't know. All right. Remind the court, both of you. It sounded like there was an argument made by Mr. Castillo about item number 4, the transfer of the Spectrum account as the fourth and final, and then the response by Ms. Soto was that that was already agreed to. Crystallize that agreement for the court.
Yes, Your Honor. So we did state for the record that the agreement was he is going to go to Spectrum and sign any paperwork to effectuate that change. The account that's currently being used by Mrs. Salinas, he's going to go and change that account number solely under her name. She's agreed that any balance on that Spectrum account, if any, she's gonna cover because she's the one that's been using. That's the extent of the agreement on Spectrum. And we can do that within. He can go tomorrow, Your Honor.
Let me ask this question then. If there's that agreement, what effect, if any, does the signing of that paperwork have on the pending LPD investigation?
I don't think any judge, but of course, I'm not gonna speak for the law enforcement because I don't know, it wasn't done at that time that the report was filed, so fixing it may help, but I don't know, I wouldn't be able to tell the court if that's gonna make that complaint go away. But I would imagine that it would help because the harm or the account would just now be listed under her name.
And is there any dispute that Ms. Salinas is a co-signatory or authorized co-agent on the previous account?
On the account where he filed the identity theft, it was only Mr. Martinez, Your Honor.
So she wasn't a co-signatory, co-authorized agent or anything? Let me see if I can summarize my thoughts and give you a decision. Both of you, Mr. Martinez and Ms. Salinas, have given the court a lot to digest. Let me pronounce and render some decisions. I don't know if the court heard this though. Mr. Martinez, pull up the microphone in front of you. No, I didn't. Mr. Martinez, you filed this divorce August 12, 2025. On that date, had you lived in Texas for 6 months?
Yes, sir.
Had you lived in Webb County for 90 days?
Yes, sir.
Is there any reasonable expectation of reconciliation with Ms. Salinas?
No, sir.
All right. Here's some decisions, and I'm just gonna call the balls and strikes as they are, black and white, for the court. So, in the Texas Family Code, section 6.003, a court may grant a divorce in favor of one spouse or the other spouse has committed adultery. Period. Point. Stop. Black and white. The question is, was there divorce during the marriage? In other words, did Mr. Martinez have relations with any other person other than his spouse before June the 4th, 2026? Well, there's various admissions, more importantly, the one today. So the court can make that finding. And that one's pretty black and white. So the court is going to grant the divorce on the basis of adultery. Now, I tried to think about what your possible response is to the separation, but the separation really, it doesn't matter. This thing was filed August 12, 2025. By that point, folks had to have been talking about some other marriage, some other relationship. And in any event, even if that weren't true, there is an engagement ring. And even if that weren't true, there's an admission that, in fact, these acts did in fact happen. So court grants the divorce on the basis of adultery. Regarding the schedule, and I think there's already agreement because you end up at the same place anyway. So sometimes the court, even as a judge or a lawyer, the court would ask, so you prove the fault ground, what result is there? There's already, I think, an agreement that Mr. Martinez would divest himself of the equity in the home. I find that that's good, right, and just with that finding of adultery so ordered. Regarding the next issue on the schedule, there is no disagreement that Mr. Martinez is scheduled for June. There is no disagreement that it would be in the children's best interest that he occupy himself with or busy himself with taking the children to all of their activities. And there are specific dates that is in their best interest, and it is specific and enforceable. It is so ordered. You are not to miss any of the activities. You're not to change any dates. I'm not allowing you to do that. You shouldn't do that. So don't even make the request. If you have to have time off from work during the month of June because they change your schedule, you're going to have to do that. You're stuck with those dates because they are specific. They are in writing. If you haven't turned over those dates to Ms. Salinas, you order to do so now. July is different because you don't have dates. No matter what happens, they're going to be at this point, it's a hypothetical because something could happen between now and then. They're not specific. They're ambiguous. We're going to have to guess what they are. Even if you get those, you're going to have to come back to court and prove what they are anyways. So I can't even grant those. So you go back to standard in the month of July. Regarding child support, here's the issue with the underemployment. It is voluntary underemployment. I understand that it's very possible and likely based on your testimony that you would have been terminated, but we'll never know that. We'll never know that because it didn't happen, and we'll never know that because the court hasn't been provided the evidence in your personnel file. So and that's what I mean by some of these decisions are just based on the evidence before the court in a vacuum of evidence that isn't before the court. So all this to say, the effect of that is that child support is hereby set at $545 beginning June the 1st with a reimbursement or a payment of past due child support in the amount of $200 per month. Regarding the Spectrum account, this is the most interesting thing in your both situation. I find that you took out your retirement, if true, and I believe it is because you testified under oath, and I have no reason to believe that you would lie. You took out your retirement to pay a lawyer to defend against some possible criminal charges or possible criminal investigation. I find that to be a community obligation, but I also find that it is in your children's best interest that you avoid any possible jail time, but the shoe also goes on the other foot. So I believe that it is in your children's best interest that Ms. Salinas not be found criminally liable for any purpose, both in the best interest of both of your children. Take that for what it's worth. Change the Spectrum account, and I make a finding that independent of whose name was on the Spectrum account, that account initially is a community obligation. Use that for whatever purposes you. But I make a finding that it is in the children's best interest that both parents avoid any jail time. I think those were the issues before the court. You are the petitioner, Ms. Soto. Anything that the court left out?
No, Your Honor, that was clear.
Mr. Castillo, did the court leave any issues out?
No, Judge.
All right. The court finds Mr. Martinez and Ms. Salinas that there is no possibility of reconciliation. The court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due honor before
June 29th at noon by submission.
Mr. Martinez, do you have any questions for the court? Ms. Salinas, do you have any questions? Court has heard no. I wish both of you very well. I wish your children all the best, and I certainly hope and pray that both of you find peace, both of you avoid any possible sentence, and that your children enjoy their activities with each and both of you. God bless you all and your families.
I live in a no-fault divorce state, so I didn't realize there was any state in the country that still had fault for the divorce, but I guess so. It's interesting though because they separated before he started dating this other person. So is that really the cause of the divorce? It didn't seem so. It seemed like they just didn't get along, because they talked about trying to separate several times before this. It just seems like that really wasn't a reason for the divorce. I didn't think they were getting along. It didn't sound like they were getting along. Neither of them thought they were getting along. And then he acted out of spite by charging her because she used his name to open his Spectrum account, or to continue the Spectrum account, which, you know, his daughters benefited from that also. So was that really right? No, it was done out of spite. But she shouldn't have done it. She wanted him to be responsible for it. That's why she did it. At least that's what I think. Because why couldn't she just go and open her own account? She didn't need him to open an account. She should have been able to do it on her own. She has a job. And then there's, the money that he took out of his retirement to pay some of his legal fees. The wife's attorney was kind of harping on that. Like, why did you do that? Now, granted, she is owed 50% of it during the time they were married. So I don't know if it would have been half of 47,000. I don't know. Maybe not. Maybe it would only been half of 30,000. But then he gave her all of the proceeds from the home sale. So it seems like she's probably better off anyway. Those are a lot of issues that were fairly interesting. And, I got the impression he is not underemployed. He tried very hard to get another job at the rate that he was making before, and he couldn't do it. So he took this job because it was better than nothing. So with that, his daughters benefited because he has a job, better than no job. Anyway, I'd like to know what you guys think of this. So please let me know. And hit the like button on your way out. Hype this video if you liked it. And I will see you all next time.